advocate now, Advocate Mogotsi.
Good afternoon.
How do I address you?
It's a difficult one. CJ, I think even Mogotsi is still fine.
Okay.
Or even my first name, it's still fine if you can.
You hold a few law degrees, a BProc, an LLB, and 2 master's degrees in law.
Correct, Chief Justice.
And you started out as a public prosecutor, then became a magistrate, where you spent a substantial time. You were a district court magistrate for 10 years, and then a regional court magistrate for 26 years, says your application form.
Correct, Chief Justice.
And now you are working for the NPA as a senior state advocate.
Correct, Chief Justice.
Since when?
I think it's since May 2023.
Right. You have acted as a judge
Correct, Chief Justice.
in Pretoria and Johannesburg. And I see that you started in 2013 and you've acted intermittently until 2022.
Not exactly, Chief Justice, because I omitted to also state that I did act in 2023, the first time of 2023. In other words, I think from that document, you'd say I acted for 64 weeks roughly. But when in actual fact, I've acted for almost a minimum, I would say minimum of 75 weeks, because those weeks do not include my acting during recess, because mainly I would still act during recess, but I would in the main be doing my partly heads. So I didn't deem it necessary to state that I acted during recess because it's in the main partly heads.
All right, so you count about 75 weeks in all. You mentioned 75 weeks.
Yes, Chief Justice.
All right. In the Gauteng division?
Both divisions, Chief Justice.
Okay. And you've also acted as an assessor in the High Court?
Yes, it was, I think, I'm not so sure, but it was around 1990, could have been 1996, 97, when I was called by the the then Uputatswana Judge President to come and act as an assessor there.
Well, you mentioned that you did not give a precise account of the the terms you've acted, because you say you lost your laptop. You don't have access to accurate information, and I was asking myself why you did not approach the division where you acted and ask them so that you give us precise information.
Chief Justice, I did approach them, and particularly the Pretoria division. And they said to me that they don't have the kind of information I was looking for. I remember I did that telephonically, and I remember speaking to, about 2-3 ladies over the phone who said ultimately that no, they do not have the kind of information I was looking for. But it's not only that I lost my laptop. It's because of, I don't know whether I should go there or I should wait.
Well, I don't know what it is you wanted to say.
I could not, you see, the time frame did not allow me to do all what I wanted to do, because I got nominated, I think, on the 10th day of June. And I've subsequently written to say that, to state clearly that I got nominated almost, I can say 48 hours before the closing date. And in my nomination, I mean, in my supplementary document, I also said that the reason why I could not write these things in detail, it's because of the time frame, firstly, but secondly, because of the fact that the 10th day of June is the day on which my mother passed on. So as I rushed home to go and arrange for the transportation of the corpse, while still there, is then that I got a telephone call that I've been nominated, meaning I had to rush back now. And it's about 150 kilometers or so to come and complete the forms. And I had only less than more or less 48 hours to do all that, while still running the funeral and trying to collate the information. But I did, in short, in brief, I did phone the Pretoria Division and ask for the, not only the Pretoria Division, I also phoned the regional, I mean the regional court manager, because I was also looking for further information from him.
But you are certain that the times you've given us are actually correct. You did act at those times.
I believe it's actually more because, like I'm saying, I tried to be conservative because I was there almost every recess. I was there. So I didn't include that. I really did not include that.
Okay. You've written judgments during your acting stints in the High Court?
Yes, Chief Justice, I did.
How many?
I did write judgments.
Oh, I thought you gave a number. Do you know how many?
I don't know, but
An estimate, maybe?
like I'm saying, I on each occasion tried to finish the files I was allocated to. So I don't know how many, but there could be, conservatively, I think they could also be close to 100 or so, because for all that period, I wrote my judgments. And that is why even today, I hardly have a partly head.
All right. And your application form lists 3 as reported. Is that correct?
I'm sorry, Chief Justice.
Your application form states that you have 3 reported judgments. Is that right?
I can say 4. It doesn't look like it includes one of the Northern Provinces Law Society versus the Heppel matter. It doesn't look like it includes the Heppel matter.
You list a number of courses and workshops, judicial courses and workshops you've attended throughout your stint as a magistrate, and I imagine as an acting judge.
Chief Justice, yes, but not all. These are just, because for 38 years, you can imagine, I attended many courses, but those I could just list out. But I attended many.
And you mentioned them because they enriched your work as a judicial officer.
Correct, CG.
All right. All right. JP Mpahlele, do you have questions for this candidate?
Thank you, CJ. I just want to follow up on the question about the short notice on the completion of the form. That you saying there were time constraints because it was completed in June. But we got an updated form, which is dated September, 26 September, after the shortlisting.
Correct, Commissioner.
And I don't think it makes it any better, this form, because in the first one, it was not very clear of how long to act. And then now you just mention it over a period of 7 years, and it could be misleading. If you're saying over a period of 7 years, and you're still raising the issue of the laptop.
Commissioner, if I said 7 years, I don't. Then it's my mistake. I must apologize. I never said. If I said 7 years, it's my mistake.
If you can go to page 10 of your form.
Page 10 of,
Yeah, the form that's dated 26th September 2025.
let me quickly go through this. I'm still trying to locate it, but if it's 7 years, I can clearly say it's a mistake. Because I remember I acted for, remember it's from 2013 to 2023. But the fact of the matter is that I was not there all the time. For instance, 2017 to 2018 could have been around June, July. 2017 to say around about November 2018, I was the acting regional court president of the Northwest Province. So I wasn't acting. That is why I, at some stage, said intermittently interrupted periods of about 10 years.
Thank you, sir. Did you have sight of page 10 that I referred you to?
I'm sorry.
Sorry, CJ, we're battling to hear JP.
Oh, my
You might
apologies.
repeat her questions.
Oh, my apologies. I was referring him to page 10 of the form dated 26 September 2025. And in that form, he's stating 9.2, it said please give the dates of your appointment. And the answer is there are many over 7 years. Then you give examples.
Yeah, and I see it. That's
You
a
see
typo.
it.
I must say it's a typographical. It was never intended to be 7 years.
It's a typo.
Yes, yes.
Okay, thank you,
It
sir.
was really, and I apologize for that. It was really never intended to be.
Okay. Can you just, on 9.3, because it's not clear, because this is a new form that we received after the shortlisting. On 9.3, can you just give a breakdown of your instincts? How much were, maybe estimation? Maybe how long, maybe per percentage in the civil code and the criminal code? You're dealing with it in 9.3, but it's not detailed.
Yes.
On the same page 10, sir?
Page 9.
10, the same one. After 9.2, it's 9.3.
I am not going to be exact, Commissioner, unfortunately, but all what I can say is that, let me say, could have been a 70 to 80% was criminal work, and maybe say 20% civil, and that is the reason why I don't know whether I should expatiate or not.
You are welcome.
Commissioner, this issue of not doing the civil work then is the one which has been prejudicing me from the year 2000. I attended the first aspirant judges course in July year 2000. And I couldn't make it from 2000 because I could not be exposed to civil work. I got nominated, I think 3 or 4 times. I declined. My first nomination was in the year 2000 by Advocate Safas of Johannesburg Bar. I went to Cape Town, attended the course, but declined to take up the I attended the course, but declined to be nominated as a judge because I wasn't sure whether because of the number of civil work I had done then, civil cases I had done then, I wasn't sure that whether it was appropriate for me to apply or not. I then got another nomination, I believe it was around 2014-15, which I declined. I got another one in 2019 from the judge I was working with in Palm Ridge. I declined. And it was simply because of this.
Okay, thank you, sir. Just for the record, you don't have any reserve judgments now?
No. I don't have a partly hate. I don't have a reserve judgment.
You don't have a partly hate?
A partly hate in the High Court or a reserve judgment. I don't have any of those.
can we go to this form of 26 September 2025 on page 11?
I'm not.
Do you have the form of 26 September? The one that you submitted recently?
The one your questions have been based on.
Yes, it's dated
I
26.
just can't locate it here, and that is why I've been using my. I don't want to delay the commission. Commissioner, is that page 11?
Yeah, I want us to look at paragraph 9.6 of the form.
Yes, Commissioner.
Saying, are there any partly held matters which you should bring to the attention of the commission? You marked yes. If so, please finish particulars. Case number 50, stroke 2020, State versus IV Baloy.
Correct, Commissioner. I mentioned it. It's
But
correct.
you just said you don't have partly held matters.
Yes, Commissioner. What happened is, as at the time I was completing this form, I was left with one case where I had to sentence. It was postponed because the defense wanted a pre-sentence report. Now, like I'm saying, I don't want to disturb the High Court's role when I'm acting. I only do my packets during recess. So immediately when they went on recess, I went there and sentenced Commissioner.
Okay, thank you. Thank you, it's noted that it's now finalized. Have you ever encountered with the Mpumalanga High Court
No.
division? Never.
I'm sorry?
Have you ever encountered, any encounter with the High Court in Mpumalanga, whether in Mbombela or Middelburg?
No, Commissioner.
Okay. Thank you, CJ.
Thank you, JP. Premi?
And thanks, Chief Justice, and greetings to Advocate Didi Mogotsi. Do you know the province called Mpumalanga, a rural province in South Africa?
A rural province. I cannot say I know Mpumalanga because when I say I cannot say I know it. I usually go there. I do go there. I go to Middelburg. I go to like Nelspruit, Coronation Park. But speaking about the rural areas, the better part of my serving as a magistrate was in the rural areas. And actually, if you allow me, Commissioner, if you allow me, actually,
No, it's fine.
I'm sorry.
I think I understand your response that you once worked in a rural area, like Mpumalanga.
Yes.
Then I will want to
yes,
know
if
you
I may-
understand
Okay.
access to justice for all, especially in a rural area, the challenges,
Yes.
as well as what you think that we can be able to do to deal with these challenges.
Correct. Commissioner, if you look at the number of years I spent as a regional court, as a magistrate, and you go through my CV, you'll immediately pick it up that I was mostly working as head of court. And you also realize that you'll realize that there was a stage where I was a chairman of case flow management committees. Now, in an effort to fight backlogs, because this is, sticking out like a sore thumb, the backlog cases. I then came up with this thing because in the rural areas, for instance, where I worked, you would get the previously disadvantaged people traveling by bus, leaving their areas at 3 a.m., and it's only one bus per day, and they'll reach the court at about 5:30, 6 in the morning, and they'll go back perhaps 3 o'clock when we are still busy with the witness. That witness must go back home. It's only one bus. Now, in the case law management system or plan we developed, which I chaired, I then came up with certain proposals to deal with this kind of situation of rural areas where transport is a problem and so on. And amongst others was that instead of starting a court at 9 o'clock, the magistrates, if they can, should at least start at about 8:30 or so. And I did the same even when I was still acting the High Court in Pretoria. My court wasn't starting at 10 o'clock. I would start at 9 o'clock at the latest. And when I'm in the regional court, for instance, or the district court, I would not even go for tea breaks, if I can tell you, just to cater for those people so that they can go back home. Because in one area, I can tell you, a witness would just, if you don't stop, a witness would just leave the witness stand and run to the bus while still testifying. So these are the kind of situation one would want, or one wanted to cap as soon as it became a chairperson of case flow management, to say, let's deal with cases of scholars during school holidays. Let's deal with cases of the elderly, the cases of pregnant women first thing in the morning, so that we release them to go and catch their buses. But then we also tried to create periodical courts so that we could reach out to these people, because some of them were not working. Remember, there's a high rate of unemployment. So the minute they can't afford to come to court, and remember also that, for instance, if you look at Garankuwa is geographically in Gauteng province, but for all intents and purposes, for the better part of the time, it was falling under Northwest. So you encounter problem about police officers transporting witnesses. They would tell you that, no, we don't have enough vans and so on. So we tried to reach out by arranging that we go for periodical courts. We would group these villages together so that we go to them, because if it's us going to them, it would be the three of us going there rather than expecting the whole bus to come there. And if you go to them, you kept this situation where a witness would want to leave a witness stand while testifying so that he or she can rush to the bus. And I did not only end up there. Even when I was facilitating at Saji, we would go around the country, maybe the three of us, because it works out cheaper if we go around the to train presiding officers rather than them flying over to, say, Gauteng province. So creating periodical courts was one of those means of accessing people in the rural area. And I must say that for the better part, as I was serving as a magistrate, what I used to do is that I actually served in all the courts of Northwest, all of them. So what I used to do is immediately when I go to this office, which would be a new office, I would take a car around so that I can quite understand my jurisdiction. And back then, I would also liaise with the traditional leaders, talk to the traditional, just get a feel of what's happening there. So that when I'm sitting back in the office, I know what's happening in my jurisdiction. I know the problems. Like I'm saying, in one area, there will be only one bus. So that is the kind of information which used to assist me to fast-track cases and to get to understand how to deal with particular cases. For instance, those who are coming, who are locals, I would then deal with them after I've dealt with those who are coming from the far-flung areas. And I remember even when 2013, when the Chief Justice, when the Judge President of Gauteng wanted to call me, that was my first acting stint. I didn't know him. I remember I was in court at around 5 o'clock because I was still dealing with these people who are locals after I have dealt with cases of those who are coming from far. And he said to me, I've been calling you, and it's now 5 o'clock. What have you been doing all along? And I said, no, Judge President, I've been in court trying to dispose, it was during school holidays, trying to work on cases of children who are attending school, because this is the only time I can access them when schools are closed. So I try to categorize cases, and I try to reach out to each and every case, because I have this in my mind that when we deal with cases, it's not sufficient more often than not to say, I have a lot of work. I believe you should deal with each case as if it's the only case, even though you have many cases in front of you. So that has been my approach. I'm not succeeding in that regard, but that is what keeps me going.
But if you may be successful on your application, what will be your area of priority?
My area of
Priority. The priorities that when you are appointed, you will have to pay special attention on. Immediately you received your appointment letter, the first time that you arrived in your office, what is it that you are going to concentrate on?
Before I can even go to my office, if I'm appointed, I'll do what I'm used to doing. I'll take my own vehicle, go around my area of jurisdiction to understand my area properly. But back to your question. As soon as I take up the office, one thing I have noticed with Mpumalanga, though I haven't acted, I get an impression that there's a need to be firm on this issue of case flow management. The first thing I would do if I get appointed would be to look at the number of cases enrolled. Actually, look at how they conducted the pre-trial conferences, because what I've seen from far, I might be wrong, Commissioner, I might be wrong, but what I've noticed from a distance is that the number of cases they enroll, they do not necessarily go through the court system. Some of them get withdrawn because they are not trial ready. So back to your question, if I get appointed, that is the area I'm going to start with. To be firm on what is undertaken during pre-trial conferences, to be firm on the question of enrolling cases which are trial ready, and to ensure that all the cases which are enrolled for trial are, of course, trialed. And this I learned from, we had a case flow management, I think in 2013, in Mokopung, which was hosted by the then Chief Justice, where we were addressed by the Chief Justice of Malaysia, where he said, amongst other things, that they only postpone if there is a death case. If there's no death case, they don't postpone. In other words, they ensure that whatever matter is enrolled is proceeded with. So that would be my starting point, Commissioner.
No, thanks, Chief Justice.
Chief Justice, can I follow up? Thank you, Mr. Mogotsi. I want to follow up on the question that was asked by the Premier when he asked you as to whether you know Mpumalanga. I didn't get an answer there, but you just gave us a background of what you did in the northern province, northwest. We wanted to know as to whether do you understand the dynamics of Mpumalanga as a rural province, the province that you want to go and serve its people. Do you think it's fair for the people of Mpumalanga to go and serve them if you don't even understand the dynamics of that province, let alone the High Court? The JP also asked you about whether you've been to the High Court of Mpumalanga, and you said no. Can you comment on that?
I thought I've touched on that, Commissioner, but I'll go back to it, Commissioner. I said, if I get appointed, I will, at my own expense, because that's what I'm used to doing. I'll go there and start rounding up the area, looking at the jurisdiction and so on. And I think also, if you look at my, although it's not reflected in my CV, also said, I give an example by saying I also worked in the whole of Northwest. I wasn't used to those areas, but I worked in all those offices because immediately when I get transferred, I used to be transferred, I got transferred to all those courts which are in Northwest. I would round the area just to get a feel of what's happening, to know the problems, so that when I'm sitting in my office, I know what's happening where. But also, it may not be 100% correct to say I don't know Mpumalanga. It should be remembered that parts of Mpumalanga, like Marapshan and so on, used to fall under, I think it's Northwest also. So there are areas I know, and there are people I know, and I do visit Mpumalanga. So it's not like I don't have a slightest knowledge of what Mpumalanga is. I don't have a slightest knowledge of the far-flung areas of Mpumalanga. It's not like that. It could well be that I don't know many areas, but I know parts of it. I have families there. I know what's happening there.
Thanks, CJ. I leave it at that. Thanks.
Thank you, CJ. Good afternoon, Mr. Mogotsi.
Afternoon, Commissioner.
I'm here. I've got a slight problem with the questionnaire that you submitted in your application. How did it come about that you completed the wrong questionnaire?
Commissioner, let me try and reiterate because I sketched out a background. I said, although I got nominated more than 2-3 times and I was declining, this time when I got nominated, it was immediately after I was busy trying to arrange for my mother's corpse to be transported to the mortuary when I received a telephone that I'm nominated. And I said I had less than 48 hours to complete the forms. And honestly, I wasn't in my sober senses because of what was happening there. And that is why I committed this mistake. I can even submit that certificates to show you that I was in that state of affairs when I had even less than, if I knew that I would be nominated, because people approach me and I've been declining all along. It's not me who approached them. So if I knew that I would be nominated, I would have acquainted myself with forms long before then. So by the time I experienced this death, I did not even know that I'm going to be nominated. And when I got nominated, I was in that state of affairs. And in that state of mind, I then completed a wrong form. I wrote in the amendment to apologize for that mistake, Commissioner. And I'm still apologizing even now for doing that. It wasn't intentional.
All right, thank you, Mr. Mogotsi. But you understand now the problem that it created because you were assessed on the basis of the information that is contained in the wrong form. Hence, the complaint or the concern of the GCB that they were unable to assess you sufficiently because you finished them with the wrong form. So some information was missing in the form that you submitted.
Commissioner, thank you so much, and I accept that. Even if I'm prejudiced, even if I'm not appointed because of that, I will accept that, Commissioner, because I did not do that out of my own. I wasn't really, because when I was busy here, I had to travel, like I said, 150 kilometers to come and complete the forms, the original forms. And back home, they were still phoning me to say, but where are you? Because we are faced with this problem. So, and I had less than 48 hours for that matter. So if this situation prejudiced me to the extent that I can be appointed, I will accept it, Commissioner.
Thank you, CJ.
Advocate Mogotsi, your CV states that you are currently contracted to prosecute truth and reconciliation cases. on behalf of the NPA. How long is that contract, may I ask? When does it terminate?
The contract is such that if any or either party wants to terminate it, we should give each other 2-3 months notice. But in any event, it's coming to an end early next year.
Early next year.
Yeah, but if
when next year?
It's probably going to be February.
All right.
But if any party wants to terminate it, you just give notice and you terminate it.
So if you are appointed next month, you would terminate your contract with them and leave things unfinished there, you say?
CJ, if you look at my nomination, the people who nominated me are from that particular sector. They said I've worked with them and they feel that I don't belong there. So once they said I don't belong there, I must go elsewhere. I think if I go to them and say I'm appointed, they will gladly release me because they are the ones who said they feel that I'm underutilized. It's not me. Like I said, these nominations, I wait for nominations to come. So if it comes to a situation where, for instance, I get appointed, it's fine. I think they will release me.
So are you saying you're not gainfully engaged there? You don't have enough work to do?
No, I have work to do, but they were saying my knowledge and experience, it's such that it can be utilized somewhere. Underutilized, not in the sense of the number of cases. Underutilized in the sense that I should serve elsewhere in a different capacity, let me put it that way. But there we are having a lot of work to do, CJ, let me say that there's a lot of work to do. Remember, we're dealing with cases where you don't even have a docket, for instance, more often than not. We're dealing with cases where you don't have original statements. But we have now started to prosecute. There's movement there, despite the fact that the documents are missing. There's movement there. So for one to deal with a matter where there's no paperwork and still take the matter to court, it shows that there is work, there is a lot of work being done there.
But they say your skills and experience are wasted there.
No, they are not saying, maybe I used the wrong word if I say it's wasted, if I said it's wasted.
That's the impression I have.
No, they are saying, society can gain better if I'm utilized in a different capacity. But they are not saying they don't want me. I can tell you they really, I'm working with them and we are working well. And I'm contributing and they're happy with what I'm doing.
You will turn 68 in December 2025, not so?
Correct, CJ.
How long would you have to serve as a judge if you are appointed?
CJ, even beyond 75, I'll be active for a number of years. But remember, if I get appointed, I'm still going to serve beyond that. And for me, Chief Justice, what is much more important is not exactly the number of years. What is very much important for me is the mark one is making, the difference one is making. If I'm able to make a mark, for instance, the reason why I was declining the nominations amongst others is that if you look at one of my masters, I did a masters in human rights. And these issues of transformation and gender equality and so, I'm aware of them. And that is why even when I was declining to be appointed as a judge, I enjoyed myself to train those who will be judges. And amongst them, obviously, there were ladies, our black ladies, and so on and so on and so on. So I was contributing in that regard towards transformation. So if I get appointed now still, the issue is the mark. The issue is the dent I will make. But beyond that, I'm prepared to serve for even if it can be 8-10 years. I'm very much prepared to serve after 10 years. But in any event, after being active, I would still serve as a retired judge should I be appointed Chief Justice. There's still energy. It would be different if I was not quite healthy. If I was quite healthy, it would be something else. But as it stands now, I'm quite healthy. And that's what I'm saying. My projection is that I'm going to serve for as long as it is possible, even if it's beyond those 8 years, even if it's 10 years, because my aim is at least to be active for the next 10 years and beyond if it's possible.
Minister, thank you very much, CJ. Good afternoon, Advocate Mogotsi.
Afternoon, Commissioner.
I'm a bit worried about your comment as minister responsible for those issues of TRC. Are you saying the work that is being done in collating, because we understand the context of having to deal with reconstructing evidence and all that, and you are saying it's fine, you'll be able to leave site. You said, how long do you have to give notice? Are you not having a case active now in the work that you are doing?
There is, Commissioner, we are working as a team. There is a case which is active now. We are working as a team because what happened there is that we acknowledge the fact that these cases are quite old, the witnesses are passing on, the accused are passing on. So we don't work as individuals. The situation is such that even if I'm here and the case is before court, that case will run in my absence. If it's a question of arguing, we sit together, hold a meeting, draft a document, and one of the counsels would go and argue. So we work as a team, and that is why they are saying, and in any event, they want to do away with these contracts because there's no money any longer. They would want to employ those who would be permanent there. But for now, we work as a team. So even if I'm not there, and there will be those who will be going on with the work.
Okay. The second question I want to ask, if I'm correct based on the questionnaire, and I'm mindful because it was saying that there's information missing. So you last acted in 2022 as a judge.
Commissioner, I said according to the form 2022 years, but I acted until the first term actually of 2023. I was acting, and like I said, I had a partly head matter. I was in court in the High Court. Was it 2 weeks ago or last week? You know, the first week. I think it was the 1st of October, so if I'm not mistaken, around that time. I was on the bench, but my last term was the first term of 2023.
Or you acted now in this? You said the last time between 2024-25, did you act?
2023.
The reason, maybe let me contextualize. I'm trying to understand. So you acted, you stopped acting because you took the responsibility in NPA, or you continue to act as a judge while you are on NPA?
Thank you, Commissioner.
As a contractor.
Thank you, Commissioner. What happened is, I was active in the High Court until the first term of 2023. So I acted for the full term of 2023. And around May, then I was then called to come and work there at NPA. So I've been with NPA since then. But then I had partly had like this one of Baloyi. So each time they're on recess, I would go there to deal with this matter. So until, like I said, I finalized it, was it a week or 2 ago? So if I go to court from 2023, it would have been mainly to finalize a partly head matter.
Or to finalize a matter that you were dealing with? Which
I started when I had a term, when I was appointed, that is, for instance, around 2023, 2022, 2023.
Okay. No, thanks. I think I wanted that clarity because I was worried about you being in the prosecution side and being a judge as well, because for me it does give that.
Yes.
Yeah, it's worrying, because even where I'm sitting, we could have handed over the matter back to somebody, but for you to still continue to sit on the bench while you are appointed by NPA, it's doesn't come across as
Yes.
correct where I'm sitting.
Correct.
I don't know if both parties were aware. Was NPA aware that you continuing with the matter in court, and was the judge president of that part? Was it Gauteng?
Yes.
Was judge president in Gauteng aware that you are appointed by NPA on contract as a prosecutor?
I don't remember informing the JP, but I remember talking with the DJP about it, because let me sketch this to you, that it wasn't like I'm starting new matters. I never started any new matter ever since I got appointed.
No, Advocate, it's not about new matter, it's not about, remember this institution in terms of their responsibilities. They must be independent of each other.
Yes.
Yes, that's why I'm asking if you disclosed to NPA that you currently have matters before court that you are still attending to while they appointed you as a Section 38. My assumption is that you are a Section 38 appointment. And similarly asking if the head of court where you were dealing with the matter was aware that you have been, because you would have appointed as an acting prior to you, as you say, prior to you being appointed in 2023 in May by NPA to deal with a prosecutorial matter. And that's what I'm asking, because there are issues here that we should be able to deal with. And if neither of them did nothing about clearly an issue that they should have attended to.
Yes. Thank you so much, Commissioner. I'm well awake to this issue of separation of powers. I'm well awake to this issue of the three arms of the government having to work independently from one another. But let me say that it's my mistake that I did not make the JP aware of that fact. I thought because I'm just finalizing an old matter. It's very much unlike if I was going to start new matters. I thought because it had gone very far. So I thought because it's just finalizing it won't affect that kind of a situation. But I must say, Minister, that I'm awake to that issue of separation of powers, and that is why I never took up a new matter, and I never even requested to act whilst completing this partly head.
Thank you, Sir.
Thank you, Minister. JB?
I want to make a follow-up. I heard you having good suggestions and your concerns about the case flow management in Mpumalanga. Had you had an opportunity to go through our practice directives and see how we deal with case flow management, both in the civil court and the criminal court?
Yes, JP, I did. That's what I'm saying. I don't have personal knowledge of what I said, but that is what I don't know where did I get it, but as I was reading, it's something I came across it. But like I'm saying, if I get appointed, it's obviously my duty to go back and read these practice directives. But that is what I casually saw, and I thought perhaps it's something which I could start with to assist the senior managers as soon as I get there.
My question is, did you read the provisions dealing with case flow management? Because now you're making suggestions as if those provisions are not there, or not adequately dealing with the issue. So that's my question. It's either you had sight of it or you did not.
I had sight of it. The problem, what I was alluding to, it's that it's not that those provisions are not there. it's complying, it's lawyers complying with the provisions. I'm aware that the provisions are there. Even now, in my bag, I have the practice directives with me now. So it's here underneath the table. They are here with me in the bag. So I'm aware of that, but it's an area where I realize that even though the management is doing their best, it looks like other parties are not coming to the party. So that's why I said that is one area where one could perhaps assist. Not to say the provisions are not there. I'm aware that they are there. I'm aware that the managers are trying to solve this situation. But I see that it needs further attention.
Yeah, but it's not attended to by the managers, but we leave
No, with due respect, I can't say that. I can't say it's not being attended
No,
to.
no, I'm saying it's not the managers who are attending to the issue. I'm just correcting you.
Okay.
And the practice directive is very clear. It's not the managers.
Thank you.
Thank you.
Thank you so much. Thank you so much. Thank you so much. I'm sorry if I said something which is untoward, but that is one area which I thought perhaps we could address if one gets there. But
Commissioner Ngwetho.
Thank you, Chief Justice. Advocate Mogotsi, did I understand you correctly when you answered the Deputy President that the reason you ended up completing the wrong form was because you had to come to Johannesburg and complete it and you had a funeral at home or a bereavement at home?
I don't remember saying Johannesburg.
Okay, well, it doesn't matter where you completed it, but you traveled an hour and 30 minutes.
Yes.
But what was the reason?
What was the reason?
Yes, why did you complete the wrong form?
I apologize for that. I said I was not in my senses. It's a mistake. I was not in my senses because of what had befallen me. So I don't know. I wasn't really in my mind. You know, like I said, I've just lost my mother, and I never foresaw it. And like I said, when I got a call, she was still lying there. She had to be removed. And at the same time, the deadline was just, I had less than 48 hours.
Yes, that's what I want to ask. I mean, how long were these positions advertised for?
Subject to correction, I think it was from May, but I was not nominated then, and I didn't know that I would be nominated. So I couldn't have completed the form when there was no nomination because I'm not the one who approached people to nominate me. At all these material times I indicated, they are approaching me, and I don't know when will they approach. For instance, during 2018, 19 or so, I wasn't approached, and that's why I did not apply. So even this time, these posts were out there, advertised there, but I did not know that one day I will be approached. Someone will say, are you prepared to take up this? I did not know. And I only got a telephone when I was in that state of affairs. I couldn't have foreseen that I will be nominated. Otherwise, I could have completed the form long before then.
Right. I don't think you've answered quite. How long were the positions advertised for?
I'm not sure. It could have been maybe 5, 6 weeks.
Yes. All right. Now, then, when you finally completed the form, one of the points that GCB points out are the cases you've cited. I just want to take you through to them because I tried to track what they were saying about these judgments. There is a section where you must set out the cases that you consider to be significant, and it says not more than 10. The first case that you cited is actually a Supreme Court of Appeal judgment.
Correct.
But it says judgments you have written.
Yeah. I think I'm not referring to my form, but I think subsequent to that, I quoted that case as a reported judgment, and I then included other judgments in subsequent forms, which are completed around September, if I'm not mistaken.
No, but I'm not asking you that. I'm asking you about the section where it says, list the judgments you have written, and
Yes,
the first judgment is a judgment of the Supreme Court of Appeal.
Yeah. The reason why I noted that judgment is that although it was not written by me, I am the one who presided in the court of first instance, which was a regional court in Mogotsi. And it was fortunately, the judgment I quoted there was written by our present CJ, basically. But I wrote the judgment, actually I didn't write it when I was in Mogotsi, it was just an extempore judgment. And that is why I sometimes talk about extempore judgment. I am the one who presided in the court of first instance. So I might have committed a mistake when I put it under that particular column.
Yes.
But I am the one who started the matter.
That is one of the points made by the GCB, that even that judgment, you did not actually write it. It was extempore.
Yes.
Then there is also another judgment you've cited, which is the Palo judgment. It is also a Supreme Court of Appeal judgment.
Correct.
Reported in 1999.
Correct.
And then there is also another judgment, which is Zondi. It is a judgment of the full court written by Stradom J.
In subsequent forms, Commissioner, I wrote judge judgments as reported judgment because I was sitting in the court of first instance. In other words, I was showing how I understand the law and how I apply the law in the court of first instance. Then subsequent to that, they got reported. So originally, I dealt with those cases.
No, I don't think we understand each other. The Palo judgment, there is no judgment written by you at all.
And
whether first instance or not, and the citation you've given is a Supreme Court of Appeal judgment. The second judgment, well, the third judgment, S versus Zondi, is a judgment written by Stradom J, in which you sat as an assessor, you did not write anything.
Which one did I?
Let's take, yes, State versus Zondi, which is the third of the four judgments that you've claimed to have written.
Commissioner, I'm not, maybe I don't quite understand because I'm saying
no, I think it's
these are cases I dealt with as a court of first instance. Now, the reason why I highlighted those cases is not strictly speaking about having written those judgments at that level. It's not about that. It was about the principles there, how I applied the principle, how I interpreted the facts, how I married the facts to the law. So and of course, this one of Monaring, for instance, where the judgment was written by our President Chair CJ. I quoted there for various reasons. Not only that I said there, not that I wrote it. I quoted it, I referred to it for various reasons. For instance, if you look at how I applied the evidence of a minor child, the delay in reporting, that is the reason why I remember back then, it was around 2004.
No,
we didn't even have the sexual offenses.
No, I understand, Mr. Mogotsi. I think both of us are of the same position right now, that the three judgments were not written by you. And the judgment of S versus Zondi, which is where we were in the conversation, was written by Stradom J. You were an assessor.
Commissioner, I'm not so sure whether I understand you correctly, because the only time I acted as assessor, it's in Palo. It's in Palo, State versus Palo. That was around 1997, 1996.
Yes, but
where I sat with Judge President Friedman.
No, I accept that. You've corrected me. I confused Friedman with Stradom. Yes. Palo was where you are an assessor, and then S versus Zondi was written by Stradom J.
Correct, JP. No, I fully understand with you. I fully agree with you. I fully agree that I did not write those judgments. And that's what I'm saying. If you remember well, Commissioner, at some point I said, because of the state affairs I found myself in, if I'm not appointed, it's fine, because I did a mistake. I was not in my sound and super senses. I've already alluded to it that there is somewhere I did mistakes because of what was going on in my mind.
So all right, that's fine.
But it's not like these cases. Perhaps I never had anything to do with them. As I said there, as the court of first instance. So it's not like I took matter from somewhere and just placed them there. But I'm saying I am not perfect, and I'm saying I committed a mistake, and I apologized in writing. And I still want to apologize even now for those mistakes.
Yes, sir. Now, it was just to say, not necessarily because you've completed the wrong form. I don't think anyone can punish you for that if you've got a good explanation. But I'm saying even the information you've given in that form is actually false. Thank you. Unless you want to say something more on that.
Commissioner, if I may come in, not to promote the dialogue, I'm not so sure whether it's fair to say, when someone is saying it's false.
Yes, all right, it's inaccurate, let's put it that way.
Sorry?
We can say it's inaccurate, let's look for a neutral term.
It's inaccurate, Commissioner, it's fine.
Yes, right.
And I once more want to apologize. From the bottom of my heart, I once more apologize. And if I lose anything, I still want to repeat, it's fine, I did a mistake, it's fine.
Thank you.
Thank you, Chief Justice. Thank you, Chief Justice. Good afternoon, Mr. Mogotsi.
Afternoon, Commissioner.
Mr. Mogotsi, Commissioner Mukaichobe has just taken you through your old form. I want to take you through your new form, the one that you submitted in September.
All right.
And I just want to deal with this treatment of, for example, the Palo judgment.
Correct.
Now, if you look at paragraph 6.3 of your new form, you've told us that in Palo you were an assessor in that matter.
Correct.
So if you look at 6.3 of the new form, it's paginated page 7 of your new form.
Page 7. Yes, I'm there.
You see, in 6.3, the question is, which cases in which you have appeared would you regard as being the most significant and why? And there you list the Palo judgment. Do you see the difficulty, Mr. Mogotsi?
In interpreting the word appeared.
Now, are you saying that because you were sitting as an assessor, to your mind, you were appearing in that matter?
Maybe I need to explain further as to what happened there and why I quoted it there. I was an assessor, but what would happen there is that when the matter was set down for quite a number of days, weeks, if I'm not mistaken, as an assessor, we would be assigned to do a research if the roll falls flat for that particular date. We were assigned to research, and we would use the court's library to research and to sit down with the presiding officer and participate in how the structure should be. Remember, we were called upon as magistrates. We were called upon because we had knowledge to a certain level of law and what was relevant and necessary. So I participated in deliberations. Maybe I may be faulted for having written it under appear, but I actively participated in deliberations. We sat down and discussed the judgment together.
Thank you, Mr. Mogotsi. Can I ask, in relation to the cases which you've listed in 6.3,
6.3.
in which of those cases did you appear as a representative of one of the parties?
Yes, I think appearing would have been of course, it would also be incorrect to you to have written it under appear.
I'm sorry, Mr. Mogotsi, you'll have to speak a bit louder. I can't hear you.
I would say it would be wrong to have classified them under this heading of appear because these are cases I presided over. So I think I classified, I put them under the wrong heading.
I see, Mr. Mogotsi, I must put a different concern to you. I've heard your explanation around why you completed the incorrect form, and I must extend my condolences to you on the loss of your late mother. The difficulty I have, though, is that you've adopted a methodology of just putting in a new form and asking us to disregard the old one. In circumstances where the deadline for the submission of applications passed, the applications were laid open for inspection for a very specific reason, so that we could get input from law bodies, from the public, on the content of your application. And through this procedure that you've used, you've actually undermined that entire process, because now you left us in a position where we don't have the benefit of the views of all the law bodies, the public, etc., on the content of your application.
Yes. Commissioner, I fully agree with you that I could not properly be evaluated because of that mistake. I fully agree with you that it's a mistake I've already alluded to. It's a mistake I wanted to draw attention to. I fully agree. And that's what I'm saying. Even if I don't make it, it's fine. But because I did not do that intentionally. I really did not do that. I can't go all out of my way to for instance, to write wrong cases under a wrong heading. I can't go all out and say I want to do this. So I'm accountable. I'm taking responsibility for that, and the fact that I could not be fully evaluated. Because, like I said, I spent 36, 37 years. I've written a lot of judgments. I could have put here a lot of cases here if I had that opportunity. So I'm saying I accept it. I'm saying I apologize for that. I'm saying
where does that leave this body then, Advocate Mogotsi? Do you accept that you've put us in a position where we are not in a position to conduct an accurate assessment of your competence, your capability as a judge? Do you accept that?
CJ, I'm accepting it because I see it keeps on coming, but I tried to amend the form. I sent a list of other cases which...
No, you've explained that a few times now. We have to look at the bottom line, which is that we do not have all the information we could have had you completed the correct form. We do not have all the information that is necessary to conduct a fair assessment of your capability as a judge. And I want you, as a judicial officer of long standing, to advise this body what it should do in the circumstances.
Thank you, CJ. Thank you so much. After my attention was drawn to this fact, I then amended the form. And I was quite surprised when I realized that it is said that my judgments cannot be found on SAFLI. I went to SAFLI and I found my other judgments. So the fact that there was reference to SAFLI and I later on amended the form, I later on drew a list of about 9-10 cases. I thought those kind of cases will be reached on SAFLI, and I thought, I've all along been thinking that members of the commission went through those cases, and therefore they are able to assess me at least on the cases which are appearing on SAFLI, and those I wrote as a supplement to the original form. So I thought my assessment would be based on that. But all what I'm saying now is that for 38 years or so, there are so many cases, other than the 10 I've included here. I have hundreds of cases which I could have included. But I thought this 10 would be enough to can evaluate me.
Are you satisfied, Commissioner Pillay?
And if I may go back and substantiate, CJ, I'm sorry to come in when I'm not invited to do so.
Yeah, go ahead.
Of the reported case which I wrote under a wrong heading, there is clearly stipulated how I applied the law. And if you look at, I think it's paragraph 12 or 13 of the judgment, which was written by your good self, there is somewhere where you assess me and where the Chief Justice is pointing out the mistakes I have done. So the reason why I wrote those kind of cases was sort of to give a balance to this commission, to say, although I have this kind of CV, there is somewhere around 2004 where I committed mistakes and which were picked up by the Chief Justice now, by you. So to give a fair balance that there was somewhere where I was committing mistakes, but at least in that particular judgment, for instance, I included it to say, look, subsequent to that, we have section 59 of the Sexual Offences and Related Matters, which I foresaw back then. I was just working on common law, but I worked on that to accept evidence of a minor child to convict. And I thought the list of cases I've submitted, the list of cases which are on SAFLI, are able to show this honorable commission that I don't convict where I'm supposed to acquit. And I'm also not acquitting where I'm supposed to convict. And that is borne out by the fact that of all the cases I have done for all these years, no cases could be found on SAFLI where my judgment was set aside. No case at all. So because there is no case which could be found on SAFLI, I could only, off my head, remember one case where my judgment was and it could be somewhere in 2013, where my conviction was set aside. And there my mistake was this, that instead of swearing in a child, I was just from the High Court, I asked the interpreter to swear in the child. And on that basis, the conviction was then set aside to say, I ought to have been the one who could have sworn in the child. But other than that, I don't have cases which were set aside, convictions or sentences which were set aside. And even if commissioners can go to SAFLI now, I'm not aware. I don't think they'll find any cases which were set aside because I convicted wrongly or I acquitted wrong ever since. I don't think they'll find one. So on the basis of that, I think that issue would adequately address my competency, would adequately address my efficiency, would adequately address my independence. In other words, those three aspects would then ultimately allay the fear of me being appointed in Mpumalanga where I never acted. Because the judgments can show that I can act efficiently. I don't have any party matter. I can act competently. I can act efficiently because I don't have a party matter. I don't have a matter which was set aside. I've been trying my level best to even the sentence. You look at the HEPL, for instance, the Northern Law Society of Provinces versus HEPL. The sanction, it was an appeal matter. The sanction I wrote there. It went on appeal in Bloemfontein. In Bloemfontein also. It was also confirmed, which shows that I can even apply a proportional sentence to the merits of the case before me. So I thought these cases were somehow will be somehow place me in a position where I can be assessed. But where I committed a mistake, Chief Justice, I once more want to apologize.
No, we've already covered that ground. Thank you, Mr. Mogotsi. Any further questions, colleagues? No? All right. We've reached the end of your interview then. Thank you for making yourself available. You're excused.